Hi everyone, my name is Delene Grant and welcome to part 7 of my presentation on denied by all entities. This is 2020 continued the criminal act against me in Canada. Okay. Systemic racism at play in Canada, denied by all entities. Please feel free to pause and read as I go along if I am going too fast. And maybe some of the information you have already seen, but I've brought forward as I go along to prove that these entities did me wrong. I was denied, okay? Denied number 15. 60 Queen Street West, Toronto, Ontario courtroom on March 2nd, 2024, motor vehicle accident dated August 8, 2019. Because of these lawyers, okay? Morley Law and Nicolini Law. Same of the Dairy and Adrian Nicolini, and also Neymark Law, Ryan Neymark and Courtney Madison. Yes, they join. Yeah, lawyers loyalty. Okay, so now we're at March 2020. Okay. Motor vehicle accidents denied by the court of law. No court appearances, no convictions. Okay, I was rear-ended. Okay, so think about that. Okay, as per the laws of Canada, summons must be served within 6 months to be valid. Summons for August 8, 2019, three-car accident, received on January 6, 2020. I got it 5 months later, okay, for hearing date of March 2nd, 2020. Summons for July 2nd, 2019, the hit and run, right? The summons was received on March 6th, 2020, 8 months later, right? For a hearing date of April 20, 2020. Doesn't you know that this summons is invalid as per Canada law? 8 months? No. Okay. I will prove it. Okay. Summons received dated January 6, 2024, rear-ended three-car accident dated August 8, 2019. 5 months after accident, I was the only one of 9 persons at court. Okay. This was a summons received, and it stated here. This accident was 8th of August 2019, and the courthouse 60 Queen Street West, and a date was set for 2nd of March 2020. Okay, I received the summons on the 6th of January 2020, as you can see. All right. I included this from legaltree.ca. Okay, we can barely make it out, but anyway, I have my doodles here. I indicated I received summons for both accidents. Their addresses were known, so yeah, the two who were guilty, right? The accidents were the addresses were known, so okay, we know where to find them. Okay, and then here, based off what was stated here, I doodled and said none of the accused attended court. It was mandatory, it was by law that the accused should attend court. Okay, there were 9 of us, right? I was the only one. 9, 7 included in the accident, plus the eyewitness, 8, and the police. Okay, 9. Okay. I was the only one of 9 persons from the scene of the accident dated August 8, 2019 who attended court. From a full courtroom, my case was placed last. Was this a statement? In the absence of the offender, the judge ruled a conviction of careless driving. You know, definite that was wrong, eh? I felt so, yeah. When you don't know the law, they can manipulate you, yeah. Yeah. This conviction was against the law of Canada, since the law stated that the offender must be present at court to answer charges. Failure to attend court meant that a warrant would be issued for an arrest. Okay. Compelling appearance, I got this from the internet again. Compelling appearance of accused before a justice and interim release. Okay. Is stated here: summons or warrant. A judge or designated justice to whom an information is referred under Section 1 and who considers that a case for doing so is made out shall issue either a summons or a warrant for the arrest of the accused to compel him or her to attend before a justice to answer to a charge of the offense charged in the information. Can you really trust the justice system? Look at that, eh? They're also criminals. They knew the law and they actually went against me. Huh? Don't you think? Please feel free to pause and read, okay? Okay. I told Ryan, okay, after it was the same date because I messaged Ryan at 11:22 p.m. Okay, and I said Ryan Neymark Law. I said, hi Ryan, the judge ruled conviction out of 8 of us. Out of 8 of us, 7 involved and 1 witness. I was the only one in attendance. I read this again. The judge ruled conviction out of conviction, full stop. Sorry, didn't see that. Out of 8 of us, 7 involved and 1 eyewitness. I was the only one in attendance. From the time of the summons was served in January, the court date in March could be easily missed. I was just making up stories, but I don't believe, well, all would miss it, okay? Guess what happened? There was no response from Neymark Law. He knew that. He didn't even guide me. He didn't even give me anything. No guidance as a lawyer, nothing. Okay? Told him, he said nothing. Okay. Denied number 16, Brampton, Ontario Court Room on April 21st, 2020 for a motor vehicle accident dated July 2nd, 2019. This was the first accident, eh? Okay? Because, again, of these lawyers, all right? This is now April 2020. Summons received in March 2020 for rear-ended hit-and-run accident dated July 2nd, 2019, 8 months after accident. No hearing, no conviction, summons invalid. All right, I'll prove it. It says summons for July 2nd, 2019, hit-and-run motor vehicle accident received on March 6, 2020. Summons received after 6 months defied the laws of Canada. 8 months summons served was invalid. This information here I've extracted from here. Okay. Same information here. I enlarged over here and I also put it in writing here. Okay, I'll read for you. As per law, part 5, that's part 5 of general provisions. Okay, it says limitation. Number 76(1). A proceeding shall not be commenced after the expiration of any limitation period prescribed by or under any act for the offense, or where no limitation period is prescribed. After 6 months, after the date on which the offense was or is alleged to have been committed. Okay? Talking about expiration date. Okay? So if a limitation wasn't set and whatever, right? We know definitely, as in the eyes of the court, the eyes of the law, 6 months. All right? Please feel free to review. Okay? As per Canadian law, all summons must be issued within 6 months. After 6 months, summons are invalid. Received the summons in the month of March 2020, 8 months since the hit-and-run motor vehicle accident dated July 2nd, 2019. There had been no court date or any conviction for this accident. Neymark Law had never inquired or gave advice about the motor vehicle accident. Okay, see here, this was the date I received the summons, 6th of March 2020. This was the date of the court in Brampton, the court house in Brampton, and it did say 21st day of April 2020. That's it right there. Okay, and this was to a motor vehicle accident July 2nd. There it is. You can only see it, but it's there. July 2nd, 2019, right in this section here. Okay. No court date. Because of COVID, they keep putting it off and they say call, and I kept calling to follow up and whatever. The next thing I was told that I will receive something in the mail. Nothing came, nothing. So this hit and run motor vehicle accident was placed under the rug. And as I said, Nemark law didn't do anything for my motor vehicle accident. Okay, as per the the motor vehicle presentation that I did some time ago, right? You could see that Nemark law waited until 2 years before he stated he had not put in any statement. He has not done anything. Okay, he had he didn't do anything for my cases at all. Nothing. Just sat on it and then threw it out. Okay. How long after a hit and run accident can you be charged? Okay, it is under, according to the Provincial Offences Act, an Ontario hit and run driver could be charged for their role in an accident up to 6 months after the collision. 6 months, right? 6 months. All right. I got the summons in 8 months after the collision takes place, unless other rules apply. This statute allows law enforcement officers to issue citations up to 6 months after the offense occurred or is alleged to have occurred. I can read and I have understanding, so I guess maybe since they make me out to just having a grade 12 education, maybe they don't think that I'm smart, I guess. Yeah, gotta make me out to be someone that, yeah, is not educated. Okay, but anyone, whether you're educated or not, you're street smart people, eh? Yeah, it's evident here that it says after 6 months, they have up to 6 months. So providing a summons after 8 months, it was against the law. Okay, anyone could know that. All right. Recovering damages from the hit and run driver. If the police manage to identify the driver, and it did, okay, of the vehicle responsible for your hit and run accident, a hit and run lawyer may be able to help you pursue legal action against them. In many cases, accident benefits are not sufficient to cover the damages incurred when victims sustain serious catastrophic injuries as the result of a hit and run accident. Yeah, the first one I guess didn't work, so that's why they came for me the second time. You understand? These people had an intent to commit murder. Yeah. What do you think? To me, that's obvious. Yeah. Okay, please feel free to pause and read. All right. Okay. Here again, as I indicated here, after two rear-ended accident in 2019 and denied a few months later by Aviva Auto Insurance, that is, Aviva Insurance Company raised my insurance rates a few times in 2020 during COVID. Can you imagine? They're really giving it to me, eh? Wow. Not working, and my auto insurance rate went up to the roof. Yeah. And threatened to cancel, threatened if I didn't pay. Wow. It says here, hit and run settlements. I enlarge it. When you have information about the driver who hit your car, you can take them to court to get the compensation you deserve. And Nemark law didn't do that for me. Wow. Nemark law owes me, eh? Okay. If you are hurt in a hit and run, you could be entitled to a major settlement in a civil suit. Please feel free to pause and read. Okay. Legally, when a car accident happens, both drivers are obligated to remain at the scene to ensure the other driver's well-being. Please feel free to pause and read, because for my hit and run, the driver reversed and then sped off. All right. Wow. Feel free to join me on my other presentation. Thank you.